Hello, everyone.
Hello.
Good morning if you're in Brazil time. Good afternoon if you're in Europe time. But I would like to welcome everyone for this very much expected event. We're about to start here, and we'll be sharing with you guys along the next an hour and a half a little overview of what's expected regarding personal data compliance program certifications and how to transform cost into value. And I'll be presenting from the beginning of this event, and I'll be joined by Benjamin and also Sebastian will be presenting from their perspectives and from their experiences, what's expected, and a glance to the future, as I like to say here, to what we have in the Brazilian data protection legislation. Welcome, everyone. Welcome, Benjamin. Welcome, Sebastian.
Thank you very much, Marcel.
Thank you very much.
Well, I think that for today's agenda, we'll be dividing the event into the firstly the Brazilian perspective of the data protection legislation and the certification process. And of course, I'll be joined right after by Dr. Sebastian Ziegler, who will be presenting his approach as the chairman of the Europrivacy International Board of Experts, and of course, bringing a very well analyzed and deeply focused analysis on how the certification process proceeds. And after that, we'll be having Benjamin, who is the COO and partner of Smart Global Governance, very good and very good friend and partner from our firm here. And after that, we'll be having a quick Q&A, questions and answers to the presentations that were just made. But of course, we will also be having a direct access to the speakers. If you have any question during the presentations, if it's a quick answer, we'll try to present them and answer them as the presentations go. And of course, if we're not able to stop the presentation to give a very lengthy and complex answer, we will be trying to address those in the end of the event. Of course, if we're unable to do so, to do the lengthy Q&A, of course, we'll be trying to I'm sorry, I think there was a connection problem here. So after the Q&A, if we're unable to answer to all the questions, of course, we'll be having direct access to all the speakers. Okay, so first, I would like to bring the little perspective that we have as towards the Brazilian legislation that we have entered, which entered into force last year, and I'll be trying to bring the approach that we have here at our law firm, Almeida Advogados, which has been using the over 20 years experience to provide clients with the utmost experience towards the corporate perspective and the corporate law perspective. And I'll try to bring the experience from those 20 years concentrated in especially digital law and privacy and data protection. And that's the idea that we'll be trying to provide, as we do to our clients, with the focus on innovation and practice of corporate law. And in this very complex environment that we have, the idea to have a multidisciplinary team of attorneys operating in 5 different offices in Brazil, and with over 250 professionals providing along with each experienced team a very specific approach as to the areas of the practice that we cover here in the firm. And I'll be providing, along with my partners, which are specialized in each and every one of their areas of the law, but giving, of course, the complete overview as how the legislations affect businesses in Brazil, or businesses which are intending to operate in Brazil, but there are multinationals operating in both Brazil and other countries, as we do. And of course, from a digital law overview, we'll be covering some of these points of view in cybersecurity, privacy, and compliance in general. During our presentation, of course, we'll be touching base on some of these aspects that we have. But the idea, of course, here is to make sure that whenever we are trying to assist clients on these matters, whether if it's cybersecurity for risk analysis and any sort of dispute, pre-litigation or litigation negotiations, whether if it's covering any of the innovation, and or whether if it's covering compliance, as we call it, digital compliance, which of course the main star of the legislation here is the LGPD. And the idea here for us today is to try to give it a quick glance as how our federal law, known as the LGPD, has impacted our clients and companies operating in Brazil since last year. The legislation itself entered into force in September last year. It was very well discussed because we did have 2 years for it to enter into force. Just to make a quick comparison, the last time our civil code was reformed and updated, and of course a very complex and a much more extended legislation. Last time it was updated from a 1916 original text to the 2002 text that we have, the reform text of the civil code. We only had 1 year to prepare companies, prepare businesses. And that's something that shows us that we did have a lot of time to cover the LGPD. We did have a lot of time to make sure that we are properly following what's expected from the legislation. So that means that since September last year, companies have the obligation to follow the LGPD, and from August this year, we're going to be having the administrative penalties, which will be able to be applied. So far, they have been suspended, partially due to the COVID-19 discussions and how COVID-19 affected companies here operating in Brazil. But nevertheless, it's an obligation that all companies must follow in order to make sure that their businesses which are operating in Brazil or that will be operating in the future, they have to make sure that they follow all the instructions and all the requirements set upon the legislation. Of course, there are some challenges which the legislation brings us. Some of them are referred to the culture of privacy that unfortunately is not very well established in the country, partially due to the fact that we did not have so far until the LGPD a specific legislation covering privacy and considering this complex digital environment that companies are operating. But of course, it goes beyond that. That's one of the main challenges. But of course, we have to make sure that all the way we operate, our internal processes, and of course, processes involving third parties are very well integrated to make sure that we protect privacy, we protect personal data wherever it is, wherever it stands, wherever it's saved, wherever it's been transmitted through, and that's a constant observation that we have to do. And of course, it starts by understanding where the personal data is, but that it goes a lot beyond that. Of course, we have to make sure that everything is really well analyzed according to where in the internal company process or with third parties that personal data is being used. And of course, since legislations come and use the enforcement penalties if companies are not compliant with them, of course, we already have some of those consequences into force since the legislation entered into force last September. And a lot of breach notifications have been given to the general audience since the legislation entered into force, partially due to the way that the news cover every incident that we have, and partially due to the fact that the legislation itself brings the need to make sure that an incident is well informed as it happens. And since the legislation is into force, we have been facing civil and collective lawsuit actions filed in both consumer and labor courts here in Brazil. And since we have a very judicialized country, which means people like to litigate in court a lot here, and that makes of course a very specific point of concern whenever you're dealing with the operation is operating here in the country, because that could sum up to thousands and sometimes tens of thousands and hundreds of thousands of lawsuits. And especially considering the fact that when we're dealing with a lot of personal data information, of course, we'll be facing the risk to be having to respond to those collective and individual lawsuits, and that could be happening anywhere in the country. What we have so far is, with the legislation into force, is of course the fact that these lawsuits are starting to be filed since last September. But of course, businesses in general, they have contractual obligations, and clients and service providers, suppliers, and in the supply chain channels, of course, are demanding companies to follow the rules that they are supposed to be following, whether if it's from a Brazilian perspective, Brazilian legislation perspective, or whether it's from a GDPR perspective or other legislations that we do have. And of course, having this final incentive to follow the legislation, not to be fined, is usually considered amongst companies the most important incentive to have been able to avoid being fined. And of course, fines can achieve very high numbers, especially here in the country. But in general, it's a very important point of concern that we have to cover. But of course, legislation itself does not mean that we have to follow it just because we're being penalized. Of course, we have to make sure that we are following the rules, not just to be avoiding those penalties. And of course, as I mentioned, contractual obligations and the fact that you could be facing lots of civil and labor lawsuits, that's of course a very important incentive in order to comply. And for compliance programs, fortunately, we are following this international on an international perspective, and on this international wave that we have of legislations protecting how you operate and for the protection of the individual, the citizens, when we are operating with this multinational complex of companies operating in different legislations. It means that if we're following the same standards as the LGPD follows the same GDPR standards, it makes a lot easier for us to make sure that we are protecting privacy. So it makes it a lot easier for us to, whenever we are doing and presenting and preparing and installing and implementing a compliance program, that we are, of course, subject to these the requirements of the legislation, but we're trying to benefit from these obligations in order to, of course, give us a more well-structured operation, privacy-wise, but information security-wise and legal-wise as well, because it is all, of course, connected. This is a multidisciplinary requirement that we have when we are implementing such a program as the LGPD or the GDPR compliance program. So, of course, when we are presenting a compliance program, when we are doing what we are supposed to do when we don't have a compliance program in place, other than just mapping and identifying all the processes that you have with the personal data being used within your operation, whether you are analyzing the compliance with each and every one of those processes, or of course, implementing the alterations, the recommendations to your processes, and of course, keeping and maintaining this compliance program, which are currently what most of the companies are facing right now, since the legislation is already into force, and since LGPD compliance programs have been set and implemented, sometimes with a very complex and deep operations, sometimes with a more superficial approach. Regardless of that, companies already have obligations, and some of that covers through the activities that the DPO, the data process, the data protection officer uses and makes sure the operation, the country operation, is well established in order to protect, of course, that company's operations and protect privacy throughout the life cycle, the personal data life cycle that we have within the company, and of course, service providers and etc. So from this perspective, I would like to just bring you the overall view from the Brazilian legislation as to our point of concern here, which is the operation through the National Data Protection Authority, which will be enforcing for the administrative penalties from August this year, but of course has already been presenting a few objectives, and some of those objectives are to concerns the regulatory the regulations that they have to set upon to make sure that the LGPD is really well established and covered and implemented here in the country. And some of that has to do with how the authority is been operating. And the beginning of their operation was a little bit trouble, because when the legislation entered into force, the ANPD, the national authority, was left behind, and it was implemented or created the legislation around six months later with the following legislation that we did have. And ever since, of course, very little has been actively done by the national authority itself. It still has a lot to cover because, of course, we are facing difficult times due to COVID-19, due to economic recession that is upon us, of course. But a lot of that has been pointed out as issues since the structure of the national authority itself is not well established yet. And regardless of that, we have been noticing a few updates and a few advancements on how the National Data Protection Authority is implementing and doing their job here in the country, and that has to do with the agenda that they are presenting. Since a lot of those complex issues that we have in the LGPD still need to be further regulated. They have to present and give this specific approach on how to implement a few of those items that are presented and required to be followed by companies operating here in the country. And when we're dealing with international transfer of personal data, the LGPD does point out the need to follow a few standards and to make sure that we are guaranteeing the protection of privacy whenever the operation is going through or using different companies operating. And some of that can be done by using certification processes to make sure that you are following standards and you have been subject to a specific analysis on how your operation is following these privacy requirements. And the idea here, of course, is to make sure that we are not only changing our operation and making sure that our operations are protecting privacy in general. As we say here, it's not enough to just be compliant. You have to show that you are compliant. And the easiest way companies usually find to show that they are compliant is through certification processes. And that was not left behind from the legislation, which is a very good advancement. But it was not as complete, if we might put it this way. It was not as complete as the GDPR was on this matter, since it just pointedly indicates the possibility to use certification procedures and to make sure that companies are covering and demonstrating that they are compliant with these privacy-related requirements. And the Articles 33 and 35, they roughly cover this possibility to use certification itself. It does present with the ability for the national authority to supervise and make sure that all operating certification companies are following these standards. But of course, if it does not cover that deeply as the GDPR does, we are pretty much left with a blank space here, which will be needed to be further implemented with the regulation that is that's going to be rolling out within the next couple of years, as we can see in the ANPD agenda that we have for 2021, 2022. And some of those phases will be covering very, very specific points of the legislation and what's expected from the certification perspective is to be covered on second phase of these actions that are being implemented according to the national authority agenda. So as I like to say here, we are facing a gap within the legislation and regulations that we have, and the fact that we do not have a specific regulation towards how the certification process is going to be rolling out in the country. The best way to give this overview and to give this window to the future, as I like to say, is of course bring the experience from the GDPR perspective, which is of course the idea towards today's event. I would just like to do this brief introduction before passing the word to Sebastian, who will be providing us with a little bit more of this GDPR experience from the certification process, so we can fully understand what's expected from us. And the fact that the EMPD is going to be following in integrating with the international perspective is what makes it so much more sense to not only use these experience that that the GDPR has been bringing us for the past couple of years, but also to make sure that national authorities, international authorities are well connected, since we're not able to just say that they operate independently, because we live in a really connected, especially digitally connected world. So without much further ado, I'd like to pass on to the presentation from Dr. Sebastian Ziegler, which will be covering the specific certification procedures and how we can allow companies, Brazilian operating companies, to benefit from such certification procedures. Please, Sebastian.
Muito obrigado, Márcio. Thank you very much. It's a pleasure to join this webinar. Thank you for the invitation. And I will try to give you some insight and perspective on the GDPR requirements for certification and how Europrivacy is addressing these requirements and how it can address us and serve as a bridge between Brazil and Europe. So let me move in the slide. So first of all, one important element to consider regarding Europrivacy, it's a certification scheme which has been developed in the context of the European Research Program. So it has been funded by the European Commission and by the Swiss Ministry for Research in order to design and develop a certification scheme that would be fully aligned with the requirements of the GDPR, so in particular Article 42 and 43, but there are in total over 70 references to GDPR certification in the GDPR itself, which means that the certification is foreseen as a major enabler for the implementation, the support, and the monitoring of the GDPR compliance in Europe and beyond. The scheme is managed by an international board of experts that I have the pleasure to chair, which brings about 30 experts in data protection, many from Europe, but not only, including one expert from Brazil. And this board of experts is in charge of maintaining the scheme, of ensuring that the scheme is not only adequate today, but can continue to be aligned with the evolution of the regulation or the requirements. So in case of jurisprudences, for instance, or regulatory changes, technology evolution also, which may have an impact on the requirements from a certification perspective. The scheme is managed administratively by the European Center for Certification and Privacy, which is located in Luxembourg. And the good news for us is that the scheme has been selected by the Luxembourgish authorities about a year ago. We've been working with them since quite a number of years, but more than a year ago, and they have formally submitted the scheme to the European Data Protection Board to start the procedure of validation under Article 42. And we are currently reaching the end of this procedure, and we will enter into the formal publication phase, hopefully early May, which will lead to an official publication of the scheme, if everything goes well, hopefully by July, August, let's say. Which means that currently it is not only the first, but the only scheme under review by EDPB to be endorsed as European seal for GDPR certification, and which is a quite nice achievement for us, as the requirements established by the EDPB and by the GDPR itself are quite complex and quite demanding. The Europrivacy scheme approach is really based on a collaborative ecosystem. So the scheme has been developed by different experts in data protection from different universities across Europe, from different background in terms of national obligation and and regulatory environments, but really trying to converge and to develop a scheme that can really address the needs and requirements of the different, not only at the European level, but also to address the needs of the different national jurisdictions in Europe and beyond Europe. So it brings together, in terms of interactions and support, the research community, of course, consulting on law firms, which can become official partners of Europrivacy, solution providers, such as smart global governance, certification bodies, experts, DPO associations, and authorities. And the idea of the ecosystem approach is also to ensure that the scheme is fully aligned with the reality and the complexity of diversity of data protection and data processing in reality. A certain number of characteristics which make Europrivacy distinct perhaps from other certification schemes. First of all, it has been really designed and built around the GDPR requirements. So really ensuring that the scheme was tailored really on the specific needs of the regulator, addressing a certain number of subtleties of the GDPR and ensuring that it was really fully aligned with these expectations and requirements. Another element, which is an important characteristic of the schemes, as I mentioned before previously, the scheme is continuously updated. So that's a major difference with other standards. For instance, if you take an ISO standards, usually it is adopted and used for 5 years before you release a new version of the standard. In the context of Europrivacy, we have regular meeting with the Europrivacy International Board of Experts to ensure that if there is a new jurisprudence, a new evolution in the regulatory environment, that we address them in the scheme to ensure that the scheme is always aligned with the evolution of the regulation. Another important element which was researched in the research program or through the research program is the extensibility of the scheme to non-EU jurisdictions. And the possibility, for instance, to deliver a Europrivacy certification that covers both the EU requirements through the GDPR and non-EU regulations. So for instance, we worked very closely with Switzerland, which has its own regulation, which is distinct from the GDPR, which has also a long experience in data protection certification, to find a way to ensure that the scheme could be used in a way that can easily address both the GDPR requirements of Article 42 and other references in the regulation, as well as the requirements of the Swiss Data Protection Act. So we're really trying to address different set of requirements in a very efficient manner in order to enable clients, applicants, companies, public administrations to certify their data processing once against two different sets of legal requirements, or more than two. And we continue to work on this model, and the whole scheme has been designed to easily integrate non-EU jurisdictions or regulations. And that's what we did also with Brazil. We have a team working currently on the complementary criteria for the Brazilian law in order to ensure that if we have a client, if there is a client somewhere who wants to certify data processing, which is partially in Europe and partially in Brazil, can use the same scheme to certify the compliance with both jurisdictions. Another important element, and that's one of the benefits of having a scheme which has been developed in the context of the European Research Program, is the fact that the scheme has been designed since day one to address emerging technologies such as artificial intelligence, blockchain, connected vehicles, smart grids, Internet of Things, smart cities, e-health, and you name them. That's quite important because we know that already now, but in the future, more and more data processing will be interacting with different technologies. And if you do not address the risk which are specific to these technologies, you may miss important requirements in order to be on the safe side of the street. Again, one of the main objectives of the scheme is not only to deliver a certificate, but it's also to enable clients, companies, public administrations, any applicant, to reduce its legal and financial risk. So it's really not, it's not only limited to demonstrating the compliance, but also at the same time to effectively reduce these legal and financial risks for the company, as that's quite important. It's important for the company internally, it's important for the DPO, for instance, of the company, but it's important also for the boards, for the board of directors, for the shareholders, also to know if they're investing in a company which is exposed to a legal and financial risk, or if this risk is properly addressed and mitigated. Another important element of the scheme is the fact that it has been really designed to be comprehensive and to be highly reliable. So we address each and every obligation that may have a risk in case of non-compliance, that may cause a risk, trigger a risk, either for the data subjects, which is one of the main purpose of the GDPR or data protection regulation, or for the data controller, the data processor, the applicant. But to have a very systematic approach. So it would have been easier, for instance, to ignore the lawfulness requirements, but it's a fundamental one, so it's one of the major source of fines at the European level. So what we need really, and the approach was really to be comprehensive and to deliver a scheme that would be meaningful not only for third parties, but for the company itself, to have the confidence that it is processing the data in an adequate and lawful manner. Another important element, which was researched and supported by the European Research Program, was the process itself, to enhance the efficiency of a certification process focused on data processing, to reduce the time and increase the efficiency of the results, the cost and result of the certification, meaning to reduce the cost while increasing the level of reliability and trustability of the result of the certification. It's a scheme which is fully ISO compliant, so it is based on ISO 17065 and 17021-1, but it is also implicitly easily combinable with ISO 27001 and 27701. It is comprehensive, so really addressing, as I mentioned, all the categories of data processing activities, all sorts of data processing activities. It is managed by an independent board of experts, international board of experts. It is supported by several online resources, tools, and supports, and that's quite important to enhance the efficiency of the process. It is also supported by, as I mentioned before, a global ecosystem of qualified partners and experts. That's also one of the reasons why the European Center for Certification on Privacy, which is managing the scheme, doesn't want to deliver a certification, or doesn't want to deliver and will not deliver consulting to clients, but will work with different partners, which are selected as highly trustable, qualified partners, to prepare clients to be certified and then to certify data processing. And this global ecosystem enables now to cover over 150 countries in the world through all partners. We have the chance to have very large partners on board. And that's one of the objectives, is to ensure that the scheme can be used, certified, and demonstrated across different jurisdictions. And then finally, the scheme was in the beginning, is, and will continue to have a very close and strong relationship with the research and innovation community, to leverage on emerging technologies and innovations to support the implementation and the use of the scheme. The scheme, the process is structured in three main steps. The first part is for a client or an applicant to document its conformity, to ensure that for each and every criteria, there are adequate evidence, elements, factual elements that can be used to demonstrate the compliance with the criteria. Then once you have a clear and complete documentation of your conformity, which can be supported by a law firm, by a consulting firm, which has the adequate expertise. So we have certain number of official partners who have been selected and assessed to be compliant with the requirements, technical and skills requirements to support the clients. Once this company has been prepared, has documented its conformity, potentially with the support of tools such as Smart Global Governance that Benjamin will present in a few minutes, then the company will invite a certification body to come and to assess and certify that the data processing is indeed complying with the requirements, with the legal and the scheme's criteria requirements. If the schemes, the data processing is validated and assessed as complying, then the certification body can deliver a Europrivacy certificates of compliance, which is a small logo you see up in the middle of the picture, EP for Europrivacy. And then these certificates will open the way to a 3 years certification, so a period of 36 months that can be renewed at the end for another period of 36 months. And during this period, you will have 2 surveillance audits that will be performed by the certification body in order to ensure that the data processing continues to comply with the requirement. And these surveillance audits are usually quite lighter audits, but they're required to ensure that the data processing continues to comply with the requirements, including with the evolution of the requirements. So if you have new legal or regulatory requirements, to ensure that there's a continuity in the compliance. And then, of course, that's what you will see here. The idea is really to enable a company, a public administration, to move away from a risk of zone, from an area of legal and financial risks, to progressively demonstrate its compliance, and then to get certified, and then to continue enhancing its compliance with the regulation. So in the case of, for instance, the company that would be located in Brazil, it could be to ensure compliance with both the GDPR and the Brazilian law regulation and data protection. And the scheme is also supported by a certain number of tools which are provided to the partners. So we have an online academy, which enables experts to get trained to the use of the scheme, to become official Europrivacy or qualified Europrivacy implementer or Europrivacy auditor. We have a community website, which is being launched now, which is so far reserved for the partners, and which enables to access over 700 documents, templates, guidelines, all sorts of resources to make the process as efficient as possible, as well as complementary tools and resources such as Privacy Pact and DPID, which are currently being, Privacy Pact is already active since quite some time, and DPID is a new service, which is a kind of global registry of data processing identifiers to simplify the management of the certification and the communication of the certification. That's it on my side. And again, just a few words before passing the token to Benjamin. One element which is very important, as I mentioned, there is more and more, and there are more and more interdependencies among controllers and processors. You have controllers who have branches in different jurisdictions. And it's quite common to have global companies which have branches in Brazil and branches in Europe at the same time, or which may be headquartered in Brazil with a branch in Europe, or headquartered in Europe with a branch in Brazil. And in this context, the usual approach, which consists to focus just on the local jurisdiction, is not satisfactory, because you will have the feeling that you will be complying with the local requirements, but not necessarily in reality with the requirements of the other jurisdictions. And that's why we work quite a lot with Europrivacy to ensure that we can extend the scheme to different jurisdictions, at least the most important one. And Brazil is clearly one of the major ones to be considered, considering the size of the country, the industrial activity of the country. It's very important to ensure that we do not transform data protection regulations into barriers to trade or barriers to data flow, but rather to leverage on data protection as an opportunity, data protection regulation as an opportunity to enhance the playing field in terms of compliance, to develop a globally fair, transparent and responsible marketplace where companies can share data with full trust. Because as you know, under the GDPR, and it's the same principle in Brazil, fundamentally as a company, you become, through the data protection regulation, not only responsible and liable to your own activities as a company, but also with the choice of your partners, B2B partners. And that's quite important to ensure that we can have this comprehensive approach in terms of data protection compliance, demonstration, and certification. And in this context, that's why the webinar has been named Creating Value. It's a great opportunity to transform all the effort that many companies have invested in ensuring that they do comply, they can comply and ensure compliance with the legal requirements, to transform it into an asset, into something that can create value for the company, that can be claimed as either a competitive advantage or an element of value for the company, and really turning this new set of constraints into an opportunity for the companies and enabling the front runners to take benefit of their efforts to demonstrate and to ensure full compliance with the regulation. So that's all on my side, and I would be pleased to answer any question you may have.
Thanks a lot, Sebastian. Thanks a lot for the explanation, and I think that we're going to be able to drink from the fount that of the experience that you have so far covering the GDPR. And I think that the idea here, of course, with this discussion, today's agenda, is to bring that experience. And we are, of course, very well excited to what is expected to be happening here. Mm-hmm. And until we do have a regulatory approach by the NPD, we have to be following the GDPR steps on this matter. And I would like to ask just a couple of questions. Sure. And fortunately, if everyone is interested into provide or a perspective or to add a question to be answered by Sebastian, he'll be taking the questions now, and if we're unable to do so after the Q&A, please forward your questions to the email or the event here that will be addressing them lately. But Sebastian, I would like to understand a little bit more, if you're able to share with us, how does this collaboration has been, been rolling out with the DPO associations, with the law firms, and how well connected and how well has Europrivacy been able to experience from people who are struggling to implement such a complex legislation within their operation. I think that this collaboration is very important. And it's, I would say it's more than important, it's crucial for giving this this direction as to the specific pains and difficulties that companies are facing. And how does this collaboration process work? And give us a little perspective on the benefits of such a collaboration.
Yeah, so the collaboration is multidimensional, and that's a very good point that you. Good question. It's important to stress again that these would not have been possible without strong support from the European Commission, from a research perspective, to really bring together the different stakeholders to ensure that we take into account different perspectives, including in Europe. In Europe, you have some countries which are based on common law, others which are based on continental law. So it's a different, you have different legal cultures, different interpretation, understanding of data protection, including within Europe. And then if you want to extend it beyond Europe, you need to take into account the specificities and to respect the differences among different jurisdictions. It's not about Europe trying to teach other countries what they have to do. It's really to respect that each country has its own sovereignty, its own legal system. And then how can we build bridges and facilitate interoperability among these different jurisdictions? And that requires to work very closely with, on one hand, I would say, very good experts in data protection from different universities, with different academic backgrounds. It's also working closely with supervisory authorities, so the national data protection. So we had contacts with quite a number of meetings, discussions with quite a number of data protection authorities. This process has been also, I have to say, so supported somewhere through the European Data Protection Board procedure, because as the scheme was submitted to the EDPB, we had formal feedback. So or feedbacks which are channeled to us from the 27 different national supervisory authorities. So understanding also some specific issues and concerns. Now at the international level, that's the reason why in the Europrivacy International Board of Experts, we bring together experts not only from Europe, but also from beyond Europe, to ensure that we have not only a European vision on the requirements, but to take into account different perspectives. And these experts are playing a very important role to adapt each and every line of the scheme, of the requirements. So it's like in a standardization process. We have regular meeting discussion to propose to rephrase maybe one paragraph in order to better address an issue that may have been identified and so on. Then we have other activities. For instance, the European Center for Certification and Privacy is working very closely also with other partners. So for instance, to give you an example, we have a formal partnership with European Law Students Association. So really engaging with 70,000 not only students, but alumni. So many law firms across Europe which have alumni who are following, interacting through ELSA, so really engaging with the community. Another example, we are organizing the Privacy Symposium Conference, where we bring together the national supervisory authorities, researchers, the law community, the research community, universities, different partners to discuss these issues and to address not only the legal requirements evolution, but also the technology evolution and how it impacts the compliance with the different regulations. So it's really, I would say, a multi-layered approach, but ensuring that we can take into account the different perspectives in terms of stakeholders, as well as in terms of geographic representation.
Sounds like a very complex operation that needs to be complex in order to, of course, give this perspective from all the sides that we have. Of course, companies are not just trying to avoid having to comply with such a complex legislation, but sometimes they're just unable to, especially considering the economics and the difficulties that we have been facing, COVID-wise, and etc. But it's good to know that when we're dealing with certificate processes, we are not adding an extra step as to the difficulty into implementing the legislation. It's quite the opposite, right? You're actually assisting and allowing companies to reach that compliance with maybe a little easier approach, because you have such a well-structured operation, and be able to collect those best practices from the market and to share those discussions and ideas makes it a lot easier for companies than to.
Absolutely. If I may add one point on that, one of the main challenges we foresee that if you want certification on data processing to be endorsed and adopted by the market, it has to be efficient. And in particular, in a context where from the EDPB and the GDPR perspective, you cannot certify a company as such. You can certify data processing under the GDPR. So that's the reason why, for instance, ISO 27701 is not eligible under Article 42 of the GDPR, because it's about certifying a management system, not data processing. And you have really to certify data processing, which makes sense because data processing is already so complex that if you would like just to certify, give a seal, a certificate to a company as a whole, it will not be realistic. It's not really serious. So we understand, but at the same time, if you need to certify maybe not all your data processing, but let's consider you have maybe 10, 15 data processing, which are particularly critical, and you want to certify them, the process has to be very efficient. And that's why we need to work, and that's where the research program was very useful, to really think out of the box. How can we streamline? How can we optimize? How can we make the scheme and the certification accessible and affordable to SMEs and even to large companies? They have to be cost efficient anyway. So it's really making the process as efficient as possible, which means at the same time that not to add any, I would say, exotic requirements So we focus really on the legal requirements. So what we try to do is to provide a methodology which enables to structure the assessment, the preparation and assessment of compliance, and to deliver a certificate. But at the same time, it is a tool for the company to monitor its compliance internally and externally. And that's quite important. Again, it's really to ensure that a company which is already fully complying with the regulation can easily embrace the certification, and then to have a structured manner to monitor and demonstrate and evidence its compliance with an independent third-party validation, or if it's internal audit, then just an internal audit, but then it's not an official certification.
That's really nice to have it clarified, because most companies still think that you're supposed to be investing to compliance programs, and after that you have to invest a lot more, and you have to go beyond and beyond and beyond. And that's not the case here. We're trying to make it easier for companies, not more difficult. When we're dealing with the certification process, you're extending your experience in this collaboration network, so companies can benefit from it, and make sure that they are following what's required by the legislation, because with so many consulting companies and firms saying that they are providing compliance programs, it's hard for companies to filter what's fully compliant, what's not fully compliant, and sometimes they could be investing quite considerable amounts of money into compliance programs that do not provide compliance at all, right?
Absolutely. And then there's always this issue of cognitive biases that even if you have a very good DPO, a knowledgeable expert, it doesn't mean because you're an expert that your vision is necessarily right. It's the same when you are entering into a plane. You always have the pilot and the co-pilot, because you need to have a second pair of eyes to check with the pilot to say, yes, it's right, everything is right. We can start. We can fly. And I think it's the same if you are a DPO of a company. You have, even if you are the best DPO in the world, let's say the most perfect ones, as long as you don't have an external validation, it's still very subjective, whatever you do. So the fact that you can request an external validation, whether through an internal audit or external audit to get a certification, then you can start validating, saying, yes, it's not only my conviction, it was validated by a third party. It's like for financial accounts. We can have an excellent accounting department, but it's always good to have an audit at the end of the year to ensure that everything is on track and everything is on the safe side.
Yes, perfect. I think that's pretty much it. That summarizes well the idea behind the certification. I have two other questions that we sent, and then I'd like to ask if you're able to spare a few more minutes with us.
Sure.
One of them would be, and that's a regular question that we do receive a lot from our clients, when to expect a LGPD version of this the Europrivacy certification that you have, of course, going on for almost 3 years now, and that's of course, as we say to clients, if you are GDPR compliant, you are LGPD compliant, because they are legislations following the same standards. They are trying to protect privacy, and they are coming from very similar times. I mean, the GDPR is from 2016, and the LGPD is 2018. It's not that far apart. And but usually that's the kind of question that we do receive a lot. And of course, it's within your business plans to operating in the country, having a GPD specific. I don't know if it's a tag or something like that to add to your GDPR procedures.
Yeah, so we already have a draft version of the complementary criteria for GPD for the Brazilian requirements. And as you mentioned, people often think that because you are GDPR compliant, you comply with other jurisdiction and regulation. That's not true. That's true that GDPR is usually a very good benchmark because it has set very high standards. So it's a good basis, I would say. If you are, you could say that if you comply with the GDPR, you comply probably with a good share of the other national requirements, but not necessarily and not always. And you have in each and every jurisdiction, we always find a certain number of specific requirements, just because human beings are smart. And I mean, you have legislators in Brazil who may have some good ideas and may sometimes identify one or two additional requirements because they identify some additional risk. It's the same with the Californian Data Protection Act. It's the same with the Japanese regulation, the Korean one, Singaporean one, the Israeli one, and so on. So you have in each jurisdictions, you may have a certain number of good ideas from the legislature to say, oh, we should also consider this risk. And then they will write it down in the regulation and the legislation. And then you have to take them into account if you want to deliver a certification. So to answer to your initial question, we already have a draft version that we are currently discussing with different experts. And we expect to have it, I would say, stabilized probably within 2 months' time, more or less. And then for the scheme itself, if there are pilots interested to use it, we are already running a certain number of pilots with partners, official partners of Europrivacy for certification. So it's really, if there is a strong interest from a company, let us know. We are pleased to connect the dots, if I may say.
Sounds great. And the fact that you are, if your company starts with the certification scheme based on the GDPR, of course, it will be a lot easier, and if not automatic, to extend it to the LGPD, because, of course, as we were mentioning, they follow the basic rules, and the same ideas is to protect privacy, regardless of being a national or international legislation. That sounds good, and I think it makes a lot of sense for companies that are trying to convert all that investment that they have done so far into compliance programs, and making sure that they can extract more than just say that, oh, I have invested this sum of money towards this compliance program. Now I have a independent overview on how my operation goes, so that it makes with no conflict of interest as to just presenting your operation as compliant. And I think that now that we have been under close to 3 years of the GDPR legislation entered into force, and the fact that we have a 36-month period for the certification, we are probably approaching the renewal of those certification, those certifications that were granted in the beginning of the GDPR, and of course, doing renewing certification is always something that companies have to be worried about, because one thing is granting the certification and showing that you have developed and you have further developed and specialized and improved within your operation is, of course, something that the company needs to prove when they are renewing their certifications. Are there any requirements for that matter, or difficulties that company could be facing when they are renewing their certifications?
Fundamentally, no, but there are specific requirements. So at least in Europrivacy, what we included in them, we have specific criteria for renewing and for surveillance audit. And one thing that we will systematically, that the auditors will have to assess systematically, is to see if the data processing complies with the regulatory changes. So for instance, to give you an example, we recently had the Schrems II jurisprudence for the privacy shield between Europe and the US. And of course, this has an impact in terms of requirements. So one thing that the auditor will have to do when it will visit the client, the applicant, is to check that the data processing does not only comply with the previous, the initial requirements, but the evolution of the regulation. And that's something very important to analyze, to see what the applicant has done to ensure this compliance. And in counterpart, what we provide from ECCP, that's why we try, so as I mentioned, to innovate in the way we we envisage future certification, not only Europrivacy, but the evolution of this industry, is also to provide a certain number of online support. So we have a complete set of resources which enables certified clients to be informed if there is any regulatory change, if there is any change in the requirements. So they're informed in real time, and then they have time to prepare to adapt before the next surveillance audit. So really trying to ensure a smooth and continuous process. That's why on this slides you see this on the right side, this green part, which is really about not only saying, okay, I have a label, I have a certificate I can show to my clients or to my partners, but it's really being in a process of continuous enhancements in terms of compliance, because the more you comply, the more you reduce your legal and financial risk for the company. And that's very important, because the hidden cost of non-complying with the regulations are really massive, very important. So Facebook could afford a 5 billion fines, but not many companies can afford this kind of fines.
That's correct. And most companies just see those big numbers as something that could be, maybe the authority would not be able to enforce. I mean, if you see your company facing a 15 million reais or 20 million euro fine, it's just the same as saying that, well, if anything goes wrong, my operation will be done, and I would not have to worry about that fine because the company will be over. And that's not the case. With the GDPR, we can see that using that enforcement tracker website, you can see small fines, but considerable fines being applicable, being applied, being issued, and companies facing maybe 20,000 euros, 30, 50, 60, 1,000, 100,000 euros, and of course that could be adding up and crippling your operation, crippling the company's resources, not just saying that, okay, you're going to be fined by the 20 million euro fine, and that's something that it makes companies distance themselves from the consequences of non-compliance, right?
Yeah. That's why it's important. As you mentioned it's I think an important difference, because many of the requirements of the GDPR were already in the previous directive. So quite a number, not all of them, but there were quite a number of elements. But before, nobody cared about the directive. And with the administrative fines, it changed, it had a disruptive effect, in the sense that it's not anymore nice to have, it's need to have. As a company, you need to comply. The same way, if you have accounting, you need to ensure proper and adequate accounting reporting through the IFRS if you're a large company. It's not an option. It's not anymore an option, which is at the same time an opportunity for front runners, because then companies who can really build strong foundations will have an edge on the market. And that's something interesting, because then it's win-win for all the parties. For the society, because the law aims at protecting citizens, if you want, but at the same time for the company, because it's an opportunity for company to create new market entries, new competitive advantages, but as well as to build B2B relationship with other companies which are complying with the regulation. So I think it can be for companies which can be proactive, it can be a great opportunity. But of course, for those which are not complying, there will be higher and higher costs for that.
That's right. Well, once again, thanks a lot, Sebastian, for your overview and your experience. It's going to be adding a lot of value to what companies are discussing here in Brazil right now. As I say, this a window to the future as to what's expected within certification processes, and the fact that we have this collaborative environment makes it a lot easier for us to assist our clients in reaching out for those certificates, but also making sure that their operations are not going to be falling apart whenever there is a incident or whenever there is any sort of request or anything like that they are not able to respond to, and transforming, as we say in the name of the event here, the high costs that involve complying with such a legislation into a value, into putting a more effectiveness in their operations. And once again, I'd like to thank thank you again for your participation and your contribution to this discussion. Of course, if you're able to continue with us, we'll be providing the Q&A space right after Benjamin's presentation. If not, everyone which might have if you might have questions to be sent to Sebastian, please forward them by email as well. If we're unable to answer to all of them by the end of the event. But once again, thanks a lot, Sebastian. And I would like to ask Benjamin to share with us all the experience that the Smart Global has been given and providing companies operating under the GDPR and of course now under the LGPD. And I'm sure Benjamin already has companies using Smart Global's platform. And
Sure.
the idea of having such a platform or platforms to assist companies how to operate with personal data information is quite essential if you are trying to be GDPR, LGPD compliant, but also to make sure that your operation is focusing on the operation itself and not just replying and answering to requests and questions. And having this structure, having this tool, this sort of tool, makes it a lot easier and actually enables companies to operate and be compliant with those regulations. And I would like to allow now Benjamin to share with us his experience and how companies can benefit from such a tool, and when they are dealing with such a complex environment to comply with those legislations. And once again, thanks a lot for sharing with us and being part of this event, Benjamin. The word is yours.
Thank you very much, Marcel. So first of all, following the intervention from Sebastian and from you, there are some challenges that were addressed. The first thing is that it's a multidisciplinary thing. Privacy addresses internal and external actors, a big variety of them. Inside the companies, all services might be involved because everyone might use personal data. On the external side, you have third-party processing data for you, and you have companies helping you on your compliance, like basically what you are doing at Almeida Advocates. And here, the first thing that we're trying to be and to represent with Smart Global is the set of tools that you would need. This is all a big orchestra, I would say, and we are trying to be the instruments for this compliance. The other thing also that we've seen, and actually I would just get back to one of the slides here from Sebastian, is that even if when you start the compliance for your company, you're more in a logic of risk mitigation. You're doing compliance basically because you want to limit the risk. With this full structure of understanding what is an end-to-end compliance logic, it's not just becoming compliant, it also going progressively towards certification, which not just means risk mitigation, it also means market access, competitive advantage, and all of this. Actually, to give you just an example from our perspective in Europe, we do not receive any more requests for information or requests from any client that doesn't involve the fact that we should be GDPR compliant. So obviously, as this is our we are providing a solution for that, we are GDPR compliant, but it's actually truly a question of market access for us today. If we were not GDPR compliant, or at least having the information to prove that we are, or that we are trying to be, then we will not have access to the markets. And simply, it's as simple as that. So now to get back on our on the discussion, here we are trying to address the different challenges of becoming compliant. So first of all, we need to identify and reduce all LGPD related and financial risk. We need to demonstrate compliance of the data processing that we are processing, and especially when it involves third party, we are to ensure up-to-date compliance. It's not just a one-time thing. We have a big challenge in the beginning, but it's not just you do it once and that's it. It's also something that you need to maintain. It's even something that Sebastian addressed about certification. Even certification runs with time and needs to be addressed and reevaluated every 6 months, if I recall. So all of this helps you to build trust and confidence with your partners, with the data subjects, so who are your clients. It can improve reputation, can ease cross-border data transfer, reduce the risk for selecting a data processor, and ultimately develop competitive advantages, as we're saying it earlier, and basically saying that working on your compliance is not just helping you not to get the fine, even if that's already a very important outcome. It also helps you to make better business, basically. So basically, how we will run this compliance is, first of all, we are providing a compliance framework based on the LGPD, and what we did for GDPR with the help of Europrivacy is that as soon as there was an actor like Europrivacy positioning for the certification, we had the chance to work with them to make it so this compliance framework on how you are going to become compliant is completely linked with the end game, which is the certification. So basically, everything that you start from becoming compliant is basically 1% more readiness for the certification somehow. So you start by having this framework where we're going to have different diagnostics. They have to be collaborative because, as we said earlier, many people can be involved. It can be internal or external. So in case you have third party involved, you need to send them some questions maybe to run some diagnostic to make sure that this third party who's managing data for you is doing it the proper way. So you're not just involved in your own privacy or LGPD compliance, but also you're kind of you kind of need to answer for your third parties compliance too. So from there and from this diagnostic, we'll be able to deliver a gap analysis and basically tell you what is compliant and what is not compliant in the way you are doing things together, or in the way your third parties are doing things for you. This will help you to understand what are the different challenges for each of them, what is the risk, and from there you can arbitrate and define your remediation plan, so your action plan to become compliant. And the thing with that is that all of these different steps is bringing you one step toward the certification, because the certification is basically about covering all the different articles of regulation like LGPD, and then for each of this article, bringing the proof that you are compliant. So it's not just about saying, yes, I do this, yes, I encrypt the data. It's about providing the proof that you are really encrypting the data. And we didn't really go into the details of what Europrivacy has been able to achieve in their referential, in the certification scheme. The thing is that you're not just saying this thing needs to be compliant. Europrivacy is also providing implementing guidelines. So basically what you need to do to become compliant, and then what are the suggested evidences you need to prove, you need to bring there. So so basically, you know what's the program, so you know what you need to be compliant to, and then to make sure that you will be ready to be certified, you know what element of proof you need, you know what reports, everything you need to provide to show that you're compliant. So progressively, even before you started the officially the certification progress, you're actually becoming more and more ready to be certified. On top of that, you can also add, because to all the questions, some people can say yes or no, and maybe sometimes this declarative mode, the fact of just documenting your compliance, might not be enough. Solution like ours are providing data discovery solutions. So basically, the tools to not just ask the question to people, but also ask question to the system. So you can put some crawlers into your different database or any system, SharePoint or things like that, that will check for you if there is data, or if there is a specific process, or if there is irregular access to the data or things like that, and really link the data that you have with the purposes that you identify during your compliance process. This also will help you to have automatic controls that will once again bring you one step toward the certification. We have, so as I was explaining, different questionnaires and diagnostics on our solution that help you to deliver this list of task and remediation plan. You're then bringing these elements of proof, and basically from there you're filling your certification documents that you could bring to sorry, yeah, we have some extra pages. I forgot about some automatic reports that you can do with our platform, so you can document what you or different teams are doing regarding the compliance, and with this provide different reports to different type of population. The management want a big sum up of the risk and global maturity percentage or things like that. You can also have very actionable reports for the users themselves, when they know exactly what is the next step, what is the next important thing that they need to do. So our platform has been developed even before we started to manage LGPD, to be adaptable to different regulation. So actually, I will just address something that is not shown here, which is the fact that we not just have GDPR, LGPD, ISO 27001, and maybe 20 other referentials. We also have a link between these referentials. So right now, if you and actually we started working with that for multinational companies in Europe who have entities in Brazil. And so basically they said GDPR contains many things that we need to do for LGPD. I don't want my Brazilian team to work everything from scratch. I want them to leverage what we've done and have their compliance being easier. And so that's exactly how we prepared our different referentials, because for each measures, each article of these different referentials, we identified the potential link between two regulations. So for the Europrivacy scheme that is addressing GDPR today, on top of what Sebastian has been talking to you about the Swiss regulation, it can even go beyond privacy, as we have a link between these different measures that you have in the GDPR and validated by the Europrivacy scheme, and ISO 27, because we have many security measures that are common between GDPR and ISO. So instead of addressing them twice. If you tell me that you are compliant to ISO, then I will maybe not need to address this point for GDPR. And it's exactly the same logic that we're implementing between GDPR and LGPD, so we can ease the compliance of the companies. And so all of this is basically bringing you to certification, as I was saying, as here you have a global recap, summary of all your compliance with all the points that you've said that you address or not, that you're compliant to or not, and you're bringing all the evidences. And all of this was prepared with directly inside the companies with someone like Marcio to help you, and at some point you can feel like you have already filled the full grid, you're ready to become compliant and to certify that. So at this point you can directly in one click ask for for the certification and transmit your file directly to the certification body that will be responsible for auditing you. And so this certification body will not have to do the I would say the main headache of the auditor, which is to collect the data. And this is also why we try to work by design, I would say, as we say for GDPR with Europrivacy, by integrating directly from the beginning all the required proof of the evidences that we will need to share. So once you have done that to make sure that you are compliant yourself, then from this work that you've done to become compliant, you get as a reward somehow the package for the auditor, so you don't have to do everything twice. So the auditor will not have to spend days and days to collect the data. It will just have directly the list of things that you've worked on with the evidence that you prepare with Marcio and his team, and all of this will help you to go towards certification, as I was saying already, faster and faster. And given the time it is, I try to accelerate a little bit, so we might keep some time for questions and answers. So thank you very much. That's it for me.
Thanks a lot for your very rich overview of how the platforms can assist clients and companies when they are dealing with these compliance programs, implementation, and of course certification procedures. Benjamin, thanks a lot for your presentation. Thanks a lot for sharing with us
Thank you
your
very much.
overview and your experience on this. And we have received a few questions that if you're able to answer them and be part of our Q&A here now, even though we are reaching the end of our event, if you're able to, I would like to direct a couple of those questions to you. And of course, if you're watching this event on the recorded version of it, feel free to send your questions to me, to myself, to Benjamin, and of course, also to Sebastian. That would be glad to answer them after the event as well. Benjamin,
Sure.
you mentioned, and that's the main topic of our event here today, is to transform cost into value. And one point that you mentioned is very interesting towards companies that are looking to receive more than just a compliance stamp on how their
Yeah.
operation is regarding the LGPD or the GDPR, but the benefits of having these tools to assist them to better use the data, either if it's personal data information or if it's not personal data information, that can benefit from encryption, can benefit from this discovery, because of course, when you are doing a discovery, using this as an example, you can discover personal data information, or you can discover other types of information that cannot be considered personal data information, but you can benefit from it. Have clients shared with you experiences and situations in which they were able to use the tool to more than just complying with the legislation. It covers a lot just to comply with the legislation, that's for sure. But have they shared with you benefits from using such a tool into their operations beyond being able to certify?
Oh yeah, definitely. So I mean, just one sure, just to make sure I understand. Is it to ask, did our were
It's mostly to see if clients have shared with you on how your operation and your system, your platform has been able to assist them by better using the data. Because when you have the platform to assist you with how they deal with personal data information, and when they are dealing with the compliance program implementation, they are often reviewing their processes as well. So as we say, when we are doing assisting clients with their operations on how to implement the LGPD compliance program, they will be able to better direct incident in the incident response perspective, regardless if it's a privacy-related incident response or if it's a general data incident response. And of course, that's a huge benefit for companies. And it's more than just being able to comply with the legislation. Yeah, you're able to make sure that your operation doesn't fall apart when you are dealing with this specific response to an incident. And of course, when you have platforms dealing and assisting companies with implementing these compliance programs and maintaining those compliance program working, that of course makes it a lot easier for them to provide this additional support. And I think that now Benjamin has returned to the connection here. And as I was saying, Benjamin, yeah, and that's funny because we're on different size places in the world, and we both had connection issues. I still have a power outage here where I am right now, which is amazing. But what I was saying is the use of the tool itself, and I was giving the example of when your company is doing a compliance program implementation. They could benefit when they have an incident response, regardless if it's a privacy-related incident response or not, if it's just a data incident, an information security incident. And having a platform such as Smart Global's platform allows companies to better understand the data that they have, and they could be using that information not only to reply to a data subject request or to a notification or any sort of doubt that their internal operation can have, but they can also use that more gathered or I would say improve the information, because everything is connected to the tool, everything is connected to the platform, and it can be using that into their advantage, regardless if it's for personal data information use or not.
Something else,
and have clients share their experiences with you. That's
actually,
what
it's
I was like to.
Yeah, it's like yeah. First of all, you collaborate, and then you will leverage from this collaboration. Using a collaborative solution, you'll be able to address something as a personal data from an end-to-end perspective. Let's say it's concerned HR. Even if it's about HR, they still need to ask their DPO some questions. They still need to ask questions to IT and all of it. And so basically, first of all, the first thing is to address all of this population together. And then from that, because you've done that, because you've identified the third parties involved, because you've asked all these questions before and have a good understanding, then let's say you have an incident, you will just need to say it concerns this processing. From there, we will tell you, you should maybe address this third party. You should maybe take care of these security measures, because for this processing activity, there was something to do. And so you can really make the link between everything that everyone is doing, everyone, each one in this different, on his side. And so this is common to non just privacy. And so obviously, our next challenge at Smart is to go beyond privacy. We are proposing solution for anti-corruption, for cybersecurity, because they are all linked. And when you have a global compliance officer that is looking at all of that with a global look, and needs to report at a direction that wants to know about the overall risk, then bringing all of these pieces together helps also to have the global view, and for the management, but also the very specific view for the specific users. And bringing all of that together, still to go back to this example of the orchestra, is like saying to the DPO, you need to be the master of this orchestra, you don't need to be the orchestra. So we are providing you the solution for you to run this orchestra by yourself.
That sounds great. And I think that it adds a lot of value to companies, knowing that they could benefit more than just, having the stamp, have the certification.
Of course, yeah.
That of course shows and differentiates them from others in the market, but making sure that they are properly using within their operation the personal data information. And sometimes the data itself that is not PII and that could be used for other purposes, they are able to do so if they are using tools such as Smart Global's tools. And of course, benefits. The other question that I had here was regarding benefits from using Smart Global's platform to comply with the legislation, but further, how could that make it easier for companies to apply for a certification? And you mentioned in your presentation,
Marcia was saying, I talked a bit about that. Yeah, basically the thing is that everything that you're doing is linked with the rest. So you're starting with some questions, some diagnostics, but each question we ask in the diagnostic is linked. Sorry, Marcia, I started to answer before I get back. So basically, each thing that you're doing is question, each task that you're doing is linked to a part of the certification. And so this part I've covered a little bit in my presentation. What we've also done with Europrivacy, with their help and with the help of the other parties involved, so consulting firms that help for GDPR, like Marcia, you will also help for GP and even maybe for GDPR, I guess. We have worked on providing a platform for each of the different companies involved. So there is the platform for the organization and themselves, for you who want to become compliant. There is a specific platform for consulting firms and law firms who help you and coach you somehow to become compliant. There is also an interface specific for the auditors. So you don't need to export your referential somehow provided to an auditor. You're just saying on the platform itself, I want to be certified. Then a certification body is appointed, and then once both signature has been done and everything, the auditor receives an access that you control on your compliance. So you're saying basically what you're giving him access to. You have prepared everything. You know in advance that regarding the full certification grid, you are like maybe let's say 80% already prepared. So you know that you will still need have to have 20% to finish. But once you start this process, the organization has its access, the auditor too, and so they can even talk together. So the auditor can come back to the organization and say, listen, for the item number 22, you provided me an evidence, but in this evidence, the article 3 and 4 doesn't allow me to certify this point. And you have kind of a chat that is very contextual, as there is a chat for each item of the certification. So for each proof that you're bringing, you can have a specific contextual discussion with the auditor. So it's really like making sure that the problem is not about gathering or providing the data. Once you've done it once with the solution, then it's a flow of data that you can distribute to the people that will need it when they will need it.
It mitigates a lot of risks, because when we're dealing with such a complex worldwide operation with multinationals, and you
Yeah.
have in the supply chain lots of suppliers, lots of partners working together to reach your final objectives, and of course adding more and more to that supply chain could result into a more riskier environment, right? And
Yeah.
of course, having this streamlined solution, integrating consultancy, integrating the certification company and entity, and using that tool to operate and use that information, gather information, extract intelligence from your operation. It makes a lot of sense for companies. And unfortunately, we have been reaching the end of our event today. We have extrapolated a few minutes for that. And of course, questions that I was able to anticipate to Benjamin and to Sebastian. Fortunately, I was able to do so. But if you're watching this event, this recorded event, please feel comfortable into sharing with us, into sending to the protection to be addressed and directed to the presenters from today's event. And once again, I would like to thank you so much, Benjamin, for being part of our event and
Thank you very
assisting
much,
us
Marcio.
into bringing this experience, and making sure that we are in fact transforming costs that company usually see when they are dealing with the GDPR or the LGPD perspective. They just see the costs, and of course being able to extract the value from that, from using Smart Global's tools, from using the legal services provided by Almeida Advogados when we are reviewing their operation into integrity, reviewing documents, reviewing policies and agreements and procedures as well, and of course having the certification as a way not just to give that stamp to show that you are compliant, but to make sure that the operation itself is really well integrated into this ecosystem that we have, and allow you as a company to improve your operation and to further develop. That's what is I was expecting from the event. So that's why I'd like to thank once again Smart Global. Thank once again ACCP and Europrivacy, and of course thank you for watching and being part of this discussion, and of course expecting you on the following events that we will have on these matters. Thanks a lot again, and take care, everyone.